kind of get started. Today we're talking about divorces and uncontested divorces and common questions and answers with regards to those issues. Today, my name is Todd Sivia, and I'm the owner of Sivia Law Firm, and I've got attorney Shannon McDonnell. Shannon, messing up your name. One of our attorneys that handles most of our divorces within our office. So thanks, Shannon, for joining on. And so kind of ground rules, what we're here to accomplish today. I don't know if everybody can see my screen or not, but we're going to go through about 5 minutes worth of question and answer, or kind of an introduction, and then we'll spend about 30-40 minutes worth of common questions and answers. And then we'll give people the opportunity to ask questions for the last 20 minutes of the presentation. So our office handles a lot of we believe in helping people through life's transition, and during this time, a lot of people have started working together and realized, you know what, my spouse is probably not the best spouse for me during this transition to being quarantined. So we wanted to talk about, what is an uncontested divorce and divorces in general. So what are some of the common questions? So the first one is, what is a no-fault divorce, Shannon?
No-fault divorce in Illinois is the basis for every divorce. Unlike some states like New York or even Oklahoma, they have a basis where you have to have a fault, whether it be adultery, whether it be a host of other different reasons that used to be codified in statute. But Illinois is not one of those states anymore. So now it means that it's just the simple fact that you want to get divorced allows you to get a divorce. So it's as simple as that. Some people still will have a reason, perhaps they're upset about something their partner has done, and that can be put into a divorce decree. However, it really has no basis, because the court is solely going to grant the divorce just based on no fault. Anything else is gratuitously added.
All right. What is an uncontested divorce?
An uncontested divorce is the best type of divorce. It's where the parties both solely agree as to the terms of why they're getting divorced, the terms as to the property and the assets and the debts. They are in agreement to everything. It usually requires, if you're able to do it yourself, great. A lot of times, and most times it is easier to have an attorney draw up the paperwork. It means that you are getting everything done. You don't need court oversight to do it, in as much as the only way or the only involvement of the court is to enter the divorce. But you don't require a judge to make any decisions for you necessarily. It means that you and your partner have hashed out everything about how to separate your lives and move forward with no disagreements that require adjudication by a court.
So what are the procedures for a divorce?
For a no-fault divorce?
No-fault divorce.
So in a no-fault divorce, in Illinois, it really goes circuit by circuit. You could, in Madison County, as an example, you would draw up a suite of documents that are required under statute. There are several documents, from an affidavit swearing that you have been separated for a number of months or a couple of years, to a petition requesting a divorce, to a final divorce decree judgment that you would give the court to enter. You would get all of that paperwork together and then have it entered by the court. In Madison County, you do not need to go to court for any other reason other than just getting this paperwork entered by the court. So really the procedures in uncontested situations is just, it's really a whole bunch of stuff that you need to get done before you go to court, but so that all of the activity is done beforehand. You get all of your ducks in a row, and then if you are represented by an attorney, that attorney can make it a lot easier, in as much as that attorney can really just walk through all those paperwork or all those papers that you got prepared beforehand. But like I said, it really varies circuit by circuit. So if you do not have a lawyer in Madison County, as an example, you would need to file your paperwork. You would then get a court date where you would have it be your entry date. So you would go with your soon-to-be ex-spouse, and you would both sit before the judge. The judge would ask you basically the questions that you have already answered in your paperwork, such as, your name is X, your name is Y. You both live at X, you have been separated since the X date, and it's called a prove up, but it's really, it's all the information that you entered. So it's really just so the court knows that you both are who you say you are, and you're getting a divorce, and there's nobody forcing you to do anything. So for uncontested, it really comes down to, it's just getting paperwork done, and then at most showing up for one court date.
Okay. One question that you mentioned, time periods. How long do you have to be separated, and when did that date actually start?
So separated is not necessarily separated by bodies. It can mean that you have mentally been separated from this person since X date. And obviously in this time, in what we're all going through right now, it can certainly mean that you've been separated from somebody for months, but you've been forced to live in the same, forced to reside in the same house. So it just means that you have to be separated in as much as you wanted the divorce. This is when you knew you wanted the divorce. In Illinois, it is a 2-year separation period. However, all you need to do in order to shorten that time period from 2 months or 2 years to 6 months is to enter an affidavit saying that you and your partner agree that you've been separated since X date, which would be 6 months prior, and you would like to proceed with the divorce. So it's at minimum 6 months. And then if you're not going to do an affidavit attesting to the same, you would put into your divorce paperwork that you've been separated 2 years.
Okay. But you don't have to be physically separated out of the house.
No, absolutely not.
Okay. So how long does a divorce usually take?
Well, assuming you have your 6-month separation period, which, like I said, is not really hard to obtain, since most people know mentally that they wanted a divorce, for months, it would take as long as just getting the paperwork completed. So if you are doing it yourself, you are your own timekeeper. If you are going through an attorney, it depends on what you're going to be having to divvy up that could add some time to the divorce paperwork. At minimum, it really shouldn't take any attorney longer than 30 to 60 days to get that paperwork drawn up for you. And like I said, if you're going through an attorney, you don't need to appear for court. So it can be as simple as just getting that paperwork completed, and then that attorney running up to the courthouse, getting it entered, and then getting those copies back to you, and then you are divorced. So I guess it really is a fact-dependent situation, but in the simplest of timelines, at the simplest of situations, with no property, no assets to divvy up, no debts to divvy up, I can't imagine it should take longer than 30 to 60 days.
So, and that's with an uncontested divorce.
Yes.
So with a contested divorce, any ballpark?
In a contested divorce, that is when you're dealing with not only your schedule, but you're obviously dealing with the schedule of a party that is your adverse at that time. So the spouse that you were divorcing then becomes your adverse. And if you guys are both going to court in proceedings that require adjudication, that means that you don't agree on things. And if you don't agree on things, we all know that you can't make other people do things easily. So it could be as simple as a 30 to 60 day period, but if you are in a contested universe of divorce, then I wouldn't be surprised if it would start at about a year and then it could take many years to complete. And that's not to say that you couldn't get a bifurcated divorce, which means that say two parties are in argument over the sale of a home. They could still get their divorce entered and then reserve the issue of the home sale proceeds and how that's supposed to be divvied up. It doesn't mean that you can't necessarily get a divorce completed, but it does mean that you could run into situations where you couldn't get maybe the whole divorce completed in a short amount of time. It's really just fact dependent situations. I've had divorces that started with two parties that did not get along about anything, and it becomes enough of an emotional roller coaster, and having to show up for court in that situation. There are so many things that can eventually get somebody to really be motivated to end it quicker than you thought it would happen. But then it could also be the flip side, where somebody could keep you in court for a much longer amount of time than you were hoping. So it could months, years. It really is fact dependent.
Of course, I got ahead of myself and went and started talking about time periods, but I think we've already covered that portion. This is just a weird question, but sometimes it happens. Somebody's quarantined somewhere else. But what if I can't locate my spouse?
If you can't locate your spouse, you would file your paperwork, and the court would set a court date for an entry of default. So even if you can't find somebody, that's not a problem. You just have to prove that you notified them. In Illinois, it requires just a good faith effort. You could post in a newspaper. There are several ways to show that you have tried to notify the party. Many times, obviously, some parties just don't want to be found. The court understands that. It's just that there needs to be a response period that is given to that party from 30 to 60 days. And it usually is more about giving it's usually more about the court schedule. So if they've got a backed up docket, then you're automatically going to fulfill the notice period that you have to give that other party before getting your divorce granted, simply by the fact that the court doesn't have time to get you into court in a short amount of time. So it's 30 to 60 days. And like I said, all you have to do is prove that you made a good faith effort under the statute. What I typically do, and what I would advise other people to do, is you do a notice in the paper, so that you could show that to the court and say, I tried.
All right. So other topics. So I have assets in the divorce. Is there anything specific that is worrisome, or and I'm sure we're going to cover pensions and a few other things, but what's some basic things, if I have assets, what is there anything specific I need to do?
So it's important for people to know that just because your name isn't necessarily on an asset doesn't mean that it's not marital. The only things that are kind of hard and fast, yours versus their or the spouse's, is usually gifts. If you can prove that you received something as a gift, then that is yours free and clear. You might have to prove it, but it's yours. They have no right to it. The same for anything that is inherited that was never commingled into a joint account with your spouse. It was not used to pay for anything marital. If you receive something in a trust, if you receive something from a deceased loved one that was part of your family, as long as you keep that separate from your marriage in all ways that you can keep it separate, then that is also something that should not come up as a divisible asset. So whenever you're dealing with a divorce, contested or uncontested, you would go through your checking accounts, you would go through your personal property, you would go through your tangible property, anything that is not a debt, anything that doesn't have a lien against it, you would consider an asset. And then you would, hopefully, in a great situation, you'd be able to go through with your soon-to-be ex-spouse and divvy it up. And it doesn't mean that you necessarily would split everything 50-50. You don't have to do that. Sometimes it makes more sense to say, you get account A, I'll take account B, even though technically you both are due your marital shares of account A and account B. So you can see where efficiency really kind of trumps the hard and fast rules when it makes sense to do so. But as a spouse getting divorced, you are due your marital share, which means that as long as it was acquired during the marriage, it is up for grabs in most situations.
Okay. I've got liabilities, and I've got debt on the house. I got debt outstanding, credit card debt. Is there anything specific on that?
So that is another, it's the same way that maybe your name isn't on an account in an asset, the same applies for a liability. If it was acquired during the marriage, you are going to have to work with your other party to get that taken care of. It can be something where your spouse might have credit card debt that you didn't necessarily know about it. It's still marital though if it came up during your marriage. You can imagine how sometimes this creates a very contentious situation because perhaps somebody didn't know about a certain debt. It really doesn't matter because in the eyes of the law, two became one, which means what that one person does, it applies to the other person as well. So if you have a house with a mortgage on it, you can see how that's kind of a mixed asset because you might have equity in your house. But whenever you are talking in terms of dividing it up in a divorce, you would first have to offset whatever liability is, whatever mortgage remains on the house, whatever liability remains on the house, and then that net amount left over is what you would consider an asset and divide that in your marital shares. But again, the general rule is that if it was acquired during the divorce, it is both parties need to figure out how to deal with it. Again, efficiency comes in the same way it does for assets. Perhaps you have 4 credit cards and your name is only on one, but you know it's marital for all 4 of them. Instead of saying, you're going to pay off half of 1 through 4, it sometimes will make sense given the balance of each card. Maybe you would only take one because it was the highest, the most indebted credit card, and then the spouse might take the other 3. And you would want to make sure that you're very specific in your paperwork because one caveat with liabilities in a divorce is that just because you get it entered in a divorce court doesn't mean that a bank is going to release you. So let's say that your spouse was told that you both had to deal with the mortgage, but your spouse's name was the sole name on the mortgage, which means that your spouse will have to deal with that. Even if the spouse was the only person named on the mortgage, it could come back to you because of the divorce, and vice versa. If you both are on the mortgage, it was ordered for your spouse to pay it because you took over other debts, then a bank will not necessarily care that a family law court said that your spouse was the person to take over this mortgage, because in the eyes of the bank, which is a different court, they have a right to go after both of you. So liabilities can become very, very sticky, and it's not necessarily something that is, once it's in that divorce paperwork, you're never going to have to deal with it again. It really requires a very thorough review. It requires very thorough wording in your divorce so that you can have protection to show a credit report perhaps, or to use in your favor in foreclosure proceedings. It's just so many different ways that you need to be protected when it comes to the liabilities division in a divorce.
And Shannon, you make a great point with regards to liabilities. I know our office has seen multiple times where divorces happened, and then we're defending against a foreclosure, or we're defending about something else, and really the person that's not responsible is the one that's pursuing it, so, or that is defending against it. So they're definitely not in the position to defend it. So yeah, that's very, very important. So
that's a good point. So that's a great example too as to why it needs to be very thorough, because although a bank is not going to care who they go after, because they're just interested in getting their money in a foreclosure, what that spouse can do to protect themselves after the fact, and the reason why it's very important for that divorce paperwork to be very thorough, is that even if you get put on the hook by a bank to deal with a foreclosure after a divorce, even though your spouse was the one that was supposed to say it or deal with it under family court decree. Then you would have this divorce decree that you could then enter in a civil court and then seek a judgment, or you could do it in family court, honestly. But you would have a judgment that you could then enforce against your spouse to get reimbursement for whatever you just went through in a foreclosure situation. So no matter what, it could end up being tedious, and it could end up being a workaround situation. But so long as your divorce decree is thorough and it goes through, who takes what and is as specific as it can possibly be, then there is a way to get everything fairly dealt with, even if it has to be a situation. That's one thing, though, that becomes an issue in many divorces, is the fact that family court is not the same as civil court. Civil court is not the same as family court, but they still work together.
Absolutely. All right. So we've talked about assets. We've talked about liabilities. What about divorce and retirement accounts?
So retirement accounts are also subject to, as they are considered an asset, whether it be a pension type fund, whether it be like a 401k contribution type fund. They are if they were acquired during marriage, even if a portion of them or of the account was acquired during the marriage, it is that there's still a marital portion to be divided. So whenever you are starting your divorce paperwork, you would go through every single pension that you or your spouse has. And like I said, that could be a true pension that you think of when you think of, your spouse retired from a corporation where she received a pension she paid into a pension for maybe 35 to 40 years. It'd be that type of traditional situation, or it could be, again, another type of fund like a 401k. Either way, you would list every kind of account you have that is a retirement account, and then you would figure out when that account began, and then you would, in attorney world, the attorney would get hold of whoever the plan facilitator is. You get more specific facts about the accounts, such as what are your policies in a divorce situation? How do you pay out your benefits? When can you pay out your benefits? Is there a way to get benefits paid out early? There's just a lot of tedious stuff that goes in with retirement accounts. But just in general terms, if it was acquired during the marriage, it is something that needs to be divided, or should technically be divided in a divorce. Just like everything else, efficiency can come into play. So even if you have maybe 4 different pension accounts, it doesn't mean that all 4 would necessarily be divvied up, because it's tedious to do a division of a retirement account. It's not as easy as just having a court say it's divided. You have to then do some other steps that I'll explain in a second. But the big thing about retirement accounts is that since it is tedious to deal with, if you had, say, 4 different retirement accounts with varying amounts in each of them, and let's say you had different marital portions of it, let's say some of these accounts were acquired prior to marriage, and there's just so many different, aspects of what could happen in these retirement accounts, it wouldn't necessarily make sense for you to want to divvy up each of those 4 accounts. It might make sense for you to say, I'll take this one, you take the 3. It's just a matter of efficiency and what the parties can agree on. But down the line, if you couldn't agree on anything, a court would most likely say, this is your marital share of each of these 4 accounts. And then you'd have to move forward with getting those divided. So as I said, it's not as simple as just having a court say that. So let's say you had your divorce decree saying that you needed to split retirement accounts A and B. After that, you have to then enter a certain type of order called a quadro or a quildro, and then you would send that to the plan, because the plan doesn't care what your divorce is. The plan cares about this certain quadro or quildro order that they recognize under federal law that has been adopted by Illinois that says, yes, we do have to divide this according to these quadro or quildro orders. So it's a 2-step process. One, you get it ordered in a divorce, and then after that, you have to do the order that the plan will honor to actually facilitate the division of those assets. But again, if it was acquired during the marriage, it's up for grabs.
And those are difficult documents to draft. It's not something that somebody a layperson can get in and really draft up themselves?
It's very tedious, and it's not a one size fits all. It's got to be tailored according to the plan. You don't know that until you request certain information from the plan administrators. It's a very tedious process as soon as you get into the world of retirement accounts.
So is there anything significant with the length of a marriage?
So no matter how long you were married, you could acquire, even if it was a 1-year marriage, you could obviously have acquired assets and debts in that 1 year. So the length of marriage matters in as much as in terms like assets and debts. If it was acquired during the marriage, then it's marital, and you're going to have to deal with it one way or another. Now, in terms of support, whether that be in maintenance or, as older generations like to call it, alimony, in Illinois it's called maintenance, or child support, that is dependent on the length of the marriage, because in Illinois we have codified it as a calculation under statute. And the length of your marriage comes into play for both child support and maintenance in order to determine not only how, in a maintenance world, not only how long or how much you would get, but how long you could get it. In child support, the length of time really matters about, depending on how old your kiddos are. And that's obviously a very relevant factor. But even in child support terms, the length of the marriage can come into play in the way that the court will decide what your support amount will be. Okay. And obviously, whenever it gets into that realm, the shorter the marriage, just in general terms, the less you're going to get or pay.
Any annulment versus divorce?
So in an annulment situation, that is codified in the Illinois statute. There are 5 separate reasons why you would be able to do it. They're whether it be in a familial relationship, you were related, whether it be you didn't consummate the marriage. There's, like I said, 5 separate reasons. Forgive me, I don't know all 5 off the top of my head, but they're rare situations. You still have to prove to the court that those situations do exist, such that an annulment is proper versus a divorce. And obviously, if you are getting a marriage annulled, that is saying that you are voiding the marriage. It means that the marriage never happened in the eyes of the law, the court, and for the rest of your life, it's never going to be something that it would be something that you would say, this never happened. That's essentially what an annulment is. Whereas a divorce says it happened and then we broke up. So with an annulment, you're not owed anything and you're not due anything. But it's a very strict guideline as to how to obtain an annulment, because like I said, there's a very limited reason or a host of reasons of why you could obtain an annulment versus a divorce.
Yeah, I was since we were on that subject, we got a question from the audience about annulment, so I wanted to pose that question. So, all right, house. Anything specific on the house beyond what we've already discussed?
Just to recap, with the house, it's important to know that if your name is not on the deed or your name is not on the mortgage, that doesn't matter. It's still marital if you lived in that house with your spouse. It might not be 100% marital. Let's say that your spouse had that home before you ever lived in it, but it would still be considered marital for whatever time in your marriage you shared in there together. Again, it could come into in a debt world. It could be something where it could be tedious because, let's say, your spouse didn't do what they were ordered to do in a divorce, and then a bank came after you for the house mortgage. Again, it could be a tedious situation where you have to go work around based on the terms of your divorce to get compensated by your spouse who didn't do what they were supposed to do per the terms of a divorce decree. A house can create a host of different situations in both an asset world or a liability world. I would say a big deal or a big thing that you should be concerned about in a house is always making sure to be specific as to where that property is located. Parcel IDs are important. It's very important to know all debt associated with that home, to be very clear about what the assets that you could get from that home are, and to also understand that what you purchased that house for is not necessarily what you're going to get it sold for. As an example, people that bought houses in like 2008, they lost their heads when they tried to sell their houses in 2014 because, you know, they paid a very large sum for the house in 2008 and then they didn't get anything for it in 2014. That doesn't mean anything. Just because you and your spouse purchased it for X amount of dollars does not mean that you are owed 50% of whatever you purchased it for. It is whatever it is sold for.
Right. Or what the current value is. Exactly.
Via appraisal. I mean, houses can become tedious as well because you have to do, you know, obviously you might not want to wait until your house is sold, so you have to figure out the value of it beforehand. And obviously that requires some sort of valuation, whether it be through an appraisal or whatever your method of choosing would be.
Okay. All right, kids.
Okay, so kids.
Kids a complicating factor?
Kids can complicate. Obviously, they're great and they're wonderful, but kids are usually the reason a marriage takes so long to become a divorce. If you agree and you and your spouse work together for your kids, that's wonderful. That is, whenever I meet with people getting a divorce, that is, you know, my biggest hope for them is that they are going to understand in some situations it's about would you rather be right or would you rather be happy? And would you rather be happy means, are your kids going to be affected, you know, beneficially or adversely? So it really is in your best interest, because it's in your kids' best interest, to always try to work with your spouse and make sure that you're not doing things against your spouse that will then, you know, hurt your children. That can be easier said than done, because obviously a divorce is a very emotional situation. Obviously your kids are, you know, if you've never lived apart from your kids, it can be just emotional turmoil, to say the least, to have to figure out a way to share your kids where you never really had to do that before. In Illinois in 2017, we changed basically everything dealing with custody. So it is no longer custody. In Illinois, we call it joint parenting responsibilities, or allocation of responsibilities and parenting time now. So it means that there isn't a parent that gets sole custody anymore. It means that parents can't get joint custody anymore. It means that everything is allocated via, you know, as to time and responsibilities. It means that one person or one parent can be allocated all the responsibility and time. That is rare, and, you know, obviously for a lot of different reasons, you hope that's not the case, because it's great whenever both parents can be involved in their kids or their kids' lives. But it really is this sliding scale situation of allocating things versus making a hard and fast adjudication of you are the sole custodian or you are the joint custodian. So whenever you're dealing with kids, you have to deal with how you are going to divvy up the responsibilities now, how you're going to divvy up the time with your kids, and then you have to divvy up the support. Again, support is based on a statutory calculation in Illinois. It is based on what it takes into account both parents' incomes, debts. It takes into account who's going to be with the children the most, and obviously the kids' age as well, or the kids' ages as well. So kids, it creates a whole new, it's really like a whole separate leg of a divorce situation, and it requires usually quite a lot of paperwork and quite a lot of time in order to get everything squared away, so that you don't have to be going to court every year based on something that somebody did, or, you know, didn't pick up your child, you know, at this time. You just want to make sure that your paperwork is very clear, so that you have a very good framework as to how you and your spouse can move forward in parenting your children. Now, that said, and this is a very big caveat, it doesn't matter if you put every word in the world in your divorce decree as it pertains to the joint parenting allocation of time and responsibilities. It requires you to really have to work with this person for the remainder of your children's childhood. So you want to get it you want to get something in there that is clear, that deals with every bullet point that you need to deal with, but you also need to understand that you can't take care of everything. There's going to be, situations that come up that you didn't anticipate, because we're dealing with kids, we're dealing with humans, we're dealing with other humans. So you just, like I said, you want to make sure that you are thorough, but it's important to realize that you can't take care of everything.
Good. And I think, you mentioned a key point, that there's nothing that we can do to effectuate everything that comes up, because if the child is 5 years old at the time of divorce, we can't anticipate what's happening at age 15 or 16 or 17, so which changes the whole ball game. So there's so much, and there, I think the point too is you got to have flexibility. You've got this child, and this child will be there until the age of 18, and you're obligated to take care of that child until they turn age 18. And if you have multiple kids, you've got multiple scenarios and different personalities that are going to have different needs. So having one good, thorough plan is great, but there has to be some built-in flexibility for the parents to between the two parties.
Absolutely. And I think you'll agree with me, in the world of family law attorneys, I think a sign of a good family law attorney is somebody that's not going to tell you, you're going to walk out of this happy. You're dealing with kids. A sign of any good deal is whenever both parties have to give in on some aspect of something. So, and another sign of a good family law attorney is somebody that is not going to be trigger happy and going to court. That attorney should be working with you to, really be fleshing it out as to whatever you might be wanting to go back to court about, or whatever you might be wanting to fight about. A good family attorney is going to really sit there and hash it out with you as to, would you rather be right, or would you rather be happy? Because again, you not only then are you dealing with this spouse that is your adverse party, but you're bringing in all these little humans that, like you said, you don't know what 5 years old is going to be compared to 11, 12. You don't know what is going to happen up until that age of 18. So you really need to have somebody that is working on your behalf realistically.
Yeah, absolutely. Because, you have a choice too in a divorce situation where, we can sit and fight about, what girlfriend or boyfriend your new spouse has, and use that as the catalyst to begin the fight. Or we can really think about it and say, hey, this is going to happen. This person's going to have, there's going to be new relationships that are built in, and have to get through that. But children are adaptable, and they're changeable, and we've got to get, you really don't want your, either between 2 and 18 years, sit there and fight for the next 18 years. It's great for attorneys, but because you're going to be paying us, but that's not our goal. Our goal is to really get a good agreement that things are resolved, and in the most efficient way possible. So
absolutely,
great point. Insurance.
So insurance is something that will come into the big picture as to who gets what, because let's say that you are under your spouse's insurance. Obviously, that is something that you're going to have to pay for. Let's say that your spouse gets free insurance through their employer, which would be wonderful. So that means that person, your spouse, will not have to consider that as a new added expense, but you will. So you can see how this can come into play in terms of trying to balance what your asset division is versus your liability division, because you might just take in this new, pretty substantial expense on a monthly basis that your spouse might not have to. In terms of getting divorced, you will not be, let's say you are named on your spouse's insurance currently. Once you get divorced, you would be subject to COBRA coverage for an amount of time. That was extended under Obamacare, and it is still something that exists. Obviously, it is more expensive than what would have been paid through employer coverage, but it does give you that time to find a new insurance cover or a provider. Due to Obamacare, you have more choices, with obviously not being shut down for pre-existing conditions and that sort of thing. But whenever you are getting divorced, it is in your best interest to make sure that you know who is going to provide your insurance after you get divorced, so that you know what that expense is going to be, what that coverage will cover, and you can kind of compare and contrast as to what you are currently receiving. And this, flip that over if you are the spouse providing insurance. It means that you need to provide during the divorce proceedings. You need to still be providing insurance for your spouse unless you've been ordered by the court otherwise, or you and your spouse have agreed otherwise. But you would still be providing insurance for your spouse, and then you would need to work with your spouse to allow them to obtain COBRA coverage after the divorce if they want to do that, or whatever they would need in order to get new insurance for them. If they need information from you, you need to give them that information. Now, when it comes into the world of children, obviously children can be under their parents' insurance until age 26. Usually that is something that can go into your child support calculation, because obviously if you are the person paying more child support, it can be offset against the fact that you were also paying for your child's insurance. So it can be something that is offset in not only your spouse but your kids, and it is something that it really requires both parties to know who the insurer is, what the coverage entails, and you need to plan before you get divorced as to how you're going to deal with insurance after. There's a lot that goes in with insurance, especially when you're dealing with people with pre-existing conditions or kids with health issues that are going to be dealt with after the fact. And usually, you also need to pay attention to what the coverage amount is versus what co-pays are versus what, bills are that are not covered by insurance. So, obviously in this day and age when so many of us have high deductible insurance, just because you have insurance doesn't mean that you're not going to be getting some pretty large health insurance or health bills. So.
All right. Cost for an insurance or cost for a divorce? Cost for divorce. Okay, so this is one of those motivators for all people getting divorced, that it's always, always, always cheaper to get a divorce that is uncontested. And that, maybe if you can even wind down, if you can wind down as many issues as possible, whether that be your assets, the childhood, or the kids getting your allocation of parenting time and responsibilities divvied up, and where you're going to go with that with your spouse, as much as you can agree on, the better. That's what makes your divorce cheaper. That's what makes your divorce quicker. It really is. Cost can. It depends on who you're going to get your divorce. It depends on if you're trying to get your divorce yourself. Obviously, the cheapest way to get a divorce is by doing it pro se, meaning you're trying to do it on your own. I think that after all this, you can see all the different ways that it becomes difficult to do it on your own, but it's not impossible. It just means that you might be missing some key areas. So I think there's a few different steps that you can take in terms of what kind of cost you could get to. So obviously your cheapest is pro se. Even if you don't want a divorce or even if you don't want to pay a divorce attorney to represent you. Let's say you and your spouse get, everything, you know what you're going to do, but you don't really know how to get it done. Then you could find an attorney that could mediate or I guess an attorney that could write up the paperwork for you. You both would chip in, whatever the cost is.
And that really varies firm per firm as to what they bill for what we call flat fee divorces. The next step would be, let's say you want to try to get this hashed out before you go to court, because you know that court is timely. Court requires you both to miss work. Court can be, court is on court schedule. It's not on your schedule. So let's say you want to try to get it all taken care of before you get to court, so that you could start contested, but end in a uncontested situation, ready for the court to enter your paperwork. Then you might find a firm that can mediate your divorce, which means that they can sit down with you. They would bill you probably for per hour, or maybe they have a rate that they do just for mediated divorces. You get set number of hours for you and your future ex-spouse to sit and hash everything out. That attorney is going to help you, get all those issues down on paper, divvied up, dealt with, so that you know how to proceed. And maybe it's that attorney, or maybe you go to a different attorney, or maybe you guys try to do the paperwork yourself. I wouldn't recommend that if you're going to an attorney to mediate it. But then you would get that paperwork drafted, and then you don't have to worry about court, because you got it all done before you had to go to court. And then, of course, you get into the world of adjudicated divorces or contested divorces, which, like we talked about in the beginning, can be, months to years. And if you are talking years, you are obviously talking about all that money that you're paying an attorney to represent you in court, all the time outside of court that you're talking to your attorney, or your attorney is talking to the opposing counsel in the matter. Divorces, in short, can be very, very expensive. The thing to remember about divorces too, it's not like we're dealing with civil court where you get some sort of huge judgment at the end where you can pay for an attorney. You have to be realistic when you have an attorney in a divorce situation, because that attorney needs to be paid. Obviously, speaking personally, we have school loans that made us an attorney that we have to pay off. We have lights that we have to keep on. So our time is our money. Divorces are not cheap when you're being represented by counsel, and so it's important to know that whether or not you can afford an attorney, and if you are going to get an attorney, how to use that attorney's time most efficiently, so that you don't get yourself in a situation after the fact where that attorney becomes your creditor, because attorneys can get out of a matter once they are in a matter if they are not getting paid. So there's a lot that goes into the cost determination of a divorce, but my quick and easy answer is that it depends, but it can be cheap or it can be very, very, very expensive.
Okay. All right. We've now gotten to the time to answer any kind of questions. So within the chat box, if you had any questions throughout the course of the presentation, and I think we were trying to answer those as we went. So if you have any questions, please feel free to send us a question, and we'll try to get it answered. One question that came in: I'm not named on the house mortgage. Can a bank still come after me for payment?
A bank could come after you once it's dealt with in the divorce. If your spouse is going to take that house in the divorce, and the debt and the assets of it, or whatever the assets would be in a sale, then that would technically mean your name never gets put onto it. But you need to make sure that your name would stay off of that house at all stages. The short answer is they could in certain circumstances, but there are ways to protect yourself so that you could not be somebody that the bank could come after. And again, even in the worst case scenario where they could, let's say it was divvied up in divorce paperwork where you are named or become named, then again, there is still recourse. It just requires a tedious workaround to get reimbursed for whatever a bank might come against you for.
Is there a specific rate applicable to alimony or maintenance?
There are multipliers under the statute, but it really depends. The multiplier depends on length of time of marriage. And like I said, it's a pretty involved statute. Like I said before, both child support and maintenance are subject to statutes that are calculations under statute that take both parents or both spouses' incomes, length of marriage, debts, a whole bunch of different things into account, and then it pops out a number at the end.
Okay. So with regards to this video, we are recording this. So we can provide this recording by email. So if you need to look back and rethink a few things, or try to think through an issue that you may have, we will definitely be providing that to those that registered here today. So, any other generalized questions? All right. Well, seeing none, thank you so much for attending our webinar. You know, if you would like to schedule a complimentary call, you're more than welcome to do so. I don't know if you can see my screen or not, but you can call. We have offices in Edwardsville and East Alton. Phone number is 618-659-4499. Or to call the East Alton address or location, it's 618-258-4800. We'll be offering a complimentary call to address any kind of additional questions and concerns. This one came in. I've been married for 3 years, no mortgage, no kids, no debts, no assets except for 2 cars. But I'm sure my spouse will ask for alimony. I'm trying to figure out how much I may have to pay. Is 3 years too? I think 3 years is pretty low.
It would be a low amount, and it would mean that somebody would not be subject to maintenance for a long amount of time, because it does take into account the time of marriage in order to determine how long somebody should get maintenance thereafter, after your divorce has been entered. But it doesn't mean that maintenance wouldn't be appropriate. If you guys, for example, if your spouse never worked and you provided all of the income for the household, then the standard is to keep that spouse in the lifestyle to which they have become accustomed for X amount of time, depending on how long you both have been married. So it doesn't mean that you wouldn't be subject to maintenance, but under the calculation and under the standards of the statute, it could not be for a long amount of time, and it would still have to provide you with, obviously, a certain amount of income to take home. But I don't want to tell you that you wouldn't have to pay maintenance at all.
Sure. Quick, one of the questions that did come in, do you work in Missouri? Yes, I'm licensed in both Illinois and Missouri. Shannon's licensed in Illinois. So we are both available, or I'm available in Missouri, and Shannon's available in Illinois. So we can definitely assist you with your needs, even if it's in Missouri. So we do have attorneys in our office that are licensed both in Illinois and Missouri. All right. Any other questions? All right. Well, thank you very much for coming in. Again, if we can ever be of service to you, let us know. Thank you.
Thank you.